Number 102, the matter of the State of New York versus Floyd Y. Counsel?
Good afternoon, Your Honor. I'd like to request 2 minutes of rebuttal.
You may.
Thank you. Alexandra Keeling, Mental Hygiene Legal Service for Floyd Y. May it please the Court. The psychological portrait presented here by the state expert mirrored that in Kenneth T., with the same state expert using the same analytical reasoning and the same language to describe Floyd Y. And the First Department went out of its way beyond the record to quote the DSM, but to conflate prongs 1 and 2 of the mental abnormality standard with their statement that pedophilia by definition involves an element of difficulty of control. But that is not what the DSM says. The First Department engaged in an armchair psychology to cure what was
the decision is not based solely on the diagnosis of pedophilia, correct?
Correct, Your Honor, in the sense that Floyd Y was diagnosed also with ASPD as well as substance use disorder. And that is exactly what Justice Convisor gets right here, where he, and at A69 of the appendix in his decision, notes that Dr. Kirshner's testimony on that second prong, about a serious difficulty of control of sexual behavior, was rooted solely in the non-paraphilic diagnoses, ASPD, and was not linked back to any paraphilic behavior, and that's what this court warns against in Kenneth T.
But doesn't the appellate division in its last paragraph or second to last say, we do not hold that all offenders who suffer from pedophilia automatically, by virtue of the diagnosis alone, are subject to mandatory management? And they go on to say, we look at everything, the diagnoses, the history of sexual misconduct, admitted inability to control his pedophilic urges, lack of satisfactory progress in sex offender treatment. So I don't see how you can read that decision to say they relied only on the diagnosis.
Well, the language that pedophilia by definition involves an element of difficulty of control is just wrong. That's not what the DSM says. But however, the other evidence that the First Department, to your question, Your Honor, is not what the record is here.
So then you're asking us to substitute our view of what the record says for the appellate division.
The question for this court is whether or not the evidence was legally sufficient.
But assuming it's what they say, you would agree they're right. You're just saying what they say is wrong.
Correct, Your Honor, and here's why it is wrong. Precisely what Justice Convisor notes in his decision is that the state expert relied precisely on what this court has said, a general tendency towards criminality, those types of behaviors. It's rooted solely in the ASPD. He uses identical language, the internal braking mechanism, a lack of conscience.
But he didn't have a lack of satisfactory progress in his sex offender treatment program. That's not an accurate statement.
That's not an accurate statement, Your Honor, to the extent that, number one, he did successfully graduates from a sex offender treatment program while he was in prison, and then his subsequent treatment, it's not that he has not completed it, he's still in it. And Dr. Kirshner's testimony is that there have been gains and setbacks, and so to say that he has failed completely, but that alone does not make this case sufficient.
What are the underlying sorts of facts on which an expert could rely to find prong 2 satisfied?
Your Honor, and that is something that this court has spoken to both in Kenneth T. and as well as in Dennis K., which reaffirms the holding in Kenneth T. and Donald D.D. that
really,
it's the detailed psychological portrait.
Slow down. It doesn't really, does it? Because I thought Dennis K. said ASPD plus borderline personality disorder was legally sufficient, and it really distinguished Kenneth T. Don't you think?
Dennis K., some of the fact patterns factually distinguishable. In terms of, one of the things that this court says in Kenneth T. are the types of evidence that's equivocal, that could be, on the one hand, go one way, and on the other hand, go another way. And one of the things that this court points out is crimes that are situational and opportunistic are not, to the converse of the question about mental abnormality, what types of facts.
Well, you're answering the obverse of my question.
And to get to that as well, Your Honor, the types of facts, it is linked back to the predicate diagnosis. Crane says that the serious difficulty of control, to the Supreme Court jurisprudence, that the serious difficulty of control must be viewed in the light of such features as the psychiatric diagnosis, as well as the severity of the mental abnormality, and everything from the crimes themselves, the circumstances surrounding the crimes themselves, yes, the diagnosis itself, and the one's progress in
Isn't
treatment.
that exactly what happened here?
No, Your Honor.
What's missing here?
Is the linkage back to the paraphilic behavior, to the
All right,
pedophilia. It's Dr.
excuse me.
Kirshner.
Can I stop you there? Kenneth T. is about paraphilia. This case is pedophilia. They aren't the same thing, and your argument presumes that they're the same thing. Isn't there a disconnect there for you?
Your Honor, it's Dr. Kirshner's testimony. Dr. Kirshner.
Well, no, let's just say on my question. My question respectfully was paraphilia is not equivalent to pedophilia. Do you agree with that
I
statement?
agree, Your Honor, of
And
course.
Kenneth T., or Kenneth, whatever his initial was about paraphilia, correct?
Correct, paraphilia and OS.
Now we're talking about pedophilia, which is certainly a defined manifestation of aberrant behavior in the DSM. There's no question about it. This court has not said that pedophilia is not one of the things that could be considered for legal sufficiency. And isn't that a distinction that we should be looking at? Because I understand your paraphilia argument, but I don't think it applies to pedophilia.
I think that gets into the two prongs of mental abnormality, Your Honor, where the pedophilia meets that first prong, which is the predicate diagnosis that predisposes one to engage in behavior that would constitute a sex offense.
Oh, we've got a man who says there's more than one prong here. There's three prongs that Kirshner was relying on, the ASPD, the pedophilia, and of course his substance abuse behavior. But also we've got a man who clearly says, I think the quote from Dr. Kirshner's testimony was when describing why he acted the way he did impulsively, he said, I want what I want when I want it. That's, I believe, a direct quote from the doctor's testimony. Isn't that something we can rely on?
Certainly one of the most quality types of evidence is an offender's own statements, but that was contextualized as to the behavior in question at that time. And moreover, Dr. Kirshner is rooting the serious difficulty of control he isolates it as to the ASPD only and does not connect it back to the pedophilia, the predicate diagnosis.
Well, I thought there was testimony from him also that that Floyd said that he had been fighting his urges toward his stepdaughter for a long time and finally gave in to them. Isn't that some indication of a tie-in between the pedophilia and an inability to control?
Well, two things, Your Honor. I mean, one, in Kenneth T., the respondent Kenneth T. himself made a statement, a one-time statement. Here, it's also a one-time statement, but that was as to that time period in question. There's a difference between the fighting the urge in those moments versus an ongoing, and there's nothing to suggest that his inability to control is ongoing. And I would just end with, it's the difference between the sick and the wicked, as the Seventh Circuit characterized it. And here, questions of serious difficulty of control are difficult logically, but it's Dr. Kirshner's testimony that mirrors Kenneth T., which this court held was insufficient. Thank you.
Thank you, counsel. Counsel? What was the detailed psychological portrait that was relied on to support
The detailed psychological portrait, as this court explained in Dennis K., consists of several components. Here, the detailed psychological portrait was made up of the specific and detailed testimony similar to that this court found sufficient in Dennis K., comprising the following pieces. Direct testimony about Floyd Y's thinking and direct evidence about how that thinking leads to a specific offense pattern. There was no testimony relied upon by the expert witness in Kenneth T. of that nature. The logical starting point to assess serious difficulty of control, as Dennis K. made clear, is the individualized characteristics of Floyd Y's diagnoses. Floyd Y suffers from the rare and powerful combination of pedophilia and ASPD. And the authoritative manual in this field, the DSM, recognizes that this specific combination causes a heightened volitional impairment, as both experts testified. And that is strong evidence of a mental abnormality.
We're familiar with that. They referred to it as a toxic mix.
Right.
But there was another element that was added, which was his participation in programs, his substance abuse problems.
That's right.
One of the things that strikes me is it seems that there's a catch-22 problem where the people that are involved in these programs are sent into the programs, and they have to either admit their past behavior, which can then be used as evidence against them, or they don't admit, and then they're cited for failure to cooperate with the programs. And this catch-22, that's how we're producing evidence, and it seems like we're producing evidence, programmatic evidence, that doesn't comport with basic due process principles.
The way forward out of that is the roadmap that this court set in the Michael M. case. The respondent in that case explained that he was able to develop practical tools for avoiding reoffending, and that would be the first and most important step. And secondly, I would say it's simply not true that people are trapped. There have been 21 instances in which people who were diagnosed with pedophilia have been released. People who were diagnosed with pedophilia and have been released, were on cyst and have now been fully discharged from all civil management. And in 19 of those 21 cases of people who've been fully discharged from cyst to no civil management.
You understand what I'm saying, though? It's usually the other forms of evidence that we're talking about. This particular form of evidence, the evidence that comes out of the programs, it still doesn't alleviate that problem.
The way forward out of the problem is to at least expect the respondent to have a plan to avoid reoffending when we're talking about proven offenses. And here, as his own expert described, he has acknowledged being sexually aroused by his stepdaughter and giving into those urges on at least 3 occasions over a 2-year period between she was 8 and 10 years old. And furthermore, as Dr. Kirshner explained to the jury, he told his expert that he was thinking to himself as he was doing it, what the hell am I doing, were his words to his expert, and he was still unable to restrain himself from offending. That's page 453.
One of the things that struck me in this case was that the testimony about his lacking of cognitive skills to be able to manage his pedophilia and also his lack of a prevention, relapse prevention program, which I think go together.
Right.
So
yeah, it's the absence of a relapse prevention program is the single most important fact that comes out of the treatment process.
Does that say that anywhere in Article 10? You need that?
That's what
Is that
Dr. Kirshner
required? I'm asking you. Is it required under Article 10 to have what you call a relapse program?
Well, what the statute requires is serious difficulty controlling one's conduct.
Okay,
and
so
Dr.
let's get
Kirshner-
back to that. Let's get back to what you said before. If he didn't have ASPD and it was just the pedophilia, would that have met the standard under Article 10? Could you have shown the second prong of the test?
Could it be shown?
Inability
Yes.
to control the urge. How so?
You would show it by putting together the full detailed psychological portrait, including the diagnoses, the extent of his success in treatment, and how that leads to a specific pattern of offending. Now, whatever the case would be in a case where it was just
I'm sorry, does that boil down to his statements? Pedophilia and his statements that I can't control my urges?
It's pedophilia. It's whether he is meaningfully engaging in treatment. And I would point out that Floyd Y made gains in treatment early on and then backslid from that. And it is the backsliding that is cause for concern. He, as recently as 2014, which was his most recent interview with his expert, he was continuing to invent implausible explanations.
Okay, so
for
again, it's
proven conduct.
what you're saying is it's the pedophilia. We've gone with the hypothetical. We're assuming someone doesn't have the ASPD. The pedophilia and the individual's statements.
Pedophilia and the overall assessment of his engagement in conduct and whether and the expert's explanation to the jury of how this manifests in a particular pattern of behavior. Let me explain what I mean
But
by...
the pattern of behavior, doesn't that rely on the crimes that he has committed, which we've already said, and Article 10 makes clear you cannot rely on for this diagnosis?
That's not what Kenneth T. said, Your Honor. Kenneth T. said that the facts of someone's sex offenses standing alone will rarely suffice to show serious difficulty. Nothing in Kenneth T. suggested that the facts of one's offenses are categorically irrelevant to showing serious difficulty, nor could that be the case. That was the fundamental error that Judge Convisor made. As the Supreme Court has recognized in the Kansas
Well,
cases...
isn't that, unless you have the profile, right, unless you have the profile that the court has referred to in the past, if you're looking at crimes that have been committed in that pattern, aren't you just hypothesizing that he will commit the crime again, as opposed to what Article 10 requires? That you've established, because it's your burden, you've persuaded the jury that indeed he cannot control these urges. So I'm just trying to figure out how you, perhaps it's more of what Judge Wilson was asking before, how you're going to be able to establish, other than the pedophilia, the inability to control urges. If
It is
ASPD alone would not give you that.
ASPD alone, this court said, and Donald D.D. would not give you that. However, whatever the case may be with someone at ASPD alone, someone who has ASPD and pedophilia, it is the single psychiatric risk factor recognized by the DSM. And here,
So then
Dr.
it boils
Kirsch-
down to what Judge Fahey was asking about, that pedophilia is not paraphilia NOS. There's something different about pedophilia that the combination allows you to get to this conclusion and determination under Article 10?
On the facts of this case and with respect to the specific combination of pedophilia and ASPD, yes, it is special because the psychiatric profession...
And is
has
that
rec-
because pedophilia is specifically about sexual urges?
It is because
Whereas
pedophilia...
paraphilia NOS is not necessarily about sexual urges?
Well, all paraphilias in some way involve sexual urges. What it's about is the fact that pedophilia, the profession has recognized that specific kind of paraphilia has a specific interaction with ASPD.
Because
And
it's the interest in the prepubescent children?
well, the interest in prepubescent children and acting on that over a period of more than 6 months, or in Floyd White's case, over a period of 2 years, that is the definition of pedophilia. It is just in the text of the DSM, it lists the risk factors for pedophilia, and there's only one psychiatric comorbidity that it lists as a risk factor for pedophilia, and that is ASPD. And getting to your question, Judge Rivera,
Does it mean
about...
if you establish that, does a jury have to determine that you've met your burden of proof?
No, there's no presumption. Pedophilia is strong evidence of mental abnormality, and the evidence is particularly strong when pedophilia is mixed with ASPD. That's when you go then to the other factors of the detailed psychological portrait. These are the same factors that the court relied upon in Dennis K.
Is it possible to enunciate a specific rule, or is this, I mean, the more I get into this, the more it feels like you know it when you see it. You know, how much is enough? Is that what we're talking about here, or can you articulate what it is that has to be shown and how you show it?
What has to be
it has to be shown, but
Right.
how do you show it?
What has to be shown is, of course, serious difficulty, and in this case it means serious difficulty sufficient to justify supervision in the community as opposed to total release from all civil management. And the way that you show it is you begin, as I said at the beginning of the argument, you begin, and this is where the court began in Dennis K., you begin with the individualized characteristics of the respondent's diagnoses, and you then, from there, it is the responsibility of the expert to provide a detailed psychological portrait, which will draw upon multiple factors. It will draw upon his success in treatment, not just his statements, but also his degree of engagement and whether he's developing a relapse prevention plan, and also the particular pattern of offending. And here, the particular pattern of offending, which is comparable to the patterns of offending described in Dennis K., particularly the Richard T.T. respondent in Dennis K., he targets people who are vulnerable because they occupy particular positions of trust in his life. And over time, he has shifted towards increasingly younger victims, culminating in his multi-year abuse of his prepubescent stepchildren. He could develop a plan to avoid reoffending, but he hasn't done so. That's the testimony that was provided here that wasn't provided in Dennis K., and that's why this court should affirm. I mean, what wasn't provided in Kenneth T., and that's why this court should affirm.
Thank you, counsel. Ms. Keeling, how significant is the absence of a relapse prevention program?
According to this court's jurisprudence, it's not significant enough to make this case sufficient. And it's a protective factor, treatment is a protective factor that does speak to someone's ability to control, but the absence of it does not mean that it does not exist. The concept of someone who's wicked, who chooses to engage in their behavior. And I take issue with the idea that the DSM says that pedophilia combined with ASPD, the comorbidity, it speaks to volitional control. It speaks to recidivism, and the difference between a risk of reoffending and the ability to control is also a fine, subtle distinction, but it's what Justice Conviser warns against, again at A71 in his decision, about these inferential shortcuts, that because someone repeats their crimes, it feels like they can't control themselves. But there is a difference between an offender who repeats their crimes by choice. And here, Dr. Kirshner's testimony, he isolates it as to the ASPD only regarding the serious difficulty of control. And when these crimes, the pattern of offending shows that these crimes are situational and opportunistic, at which this court in Kenneth T. notes crimes of opportunities do not have that sufficient quality. It's not that the quantum...
Does the substance abuse diagnosis add anything to this mix?
Certainly, Your Honor, the substance abuse diagnosis, speaks to the first prong, and as well as to serious difficulty of control, but it's not linked back to the paraphilic behavior and the pedophilia here.
What do you mean by link? What do you mean by link? Because that seems to be the nub of your argument. You know, when you've been presented with various questions from this bench on what's missing, you know, what do you need, you keep talking about a link. Give me a specific example of what that link would look like.
Well, I think, conversely to my adversary, Richard T.T. Shows the linkage between his predicate diagnosis and his serious difficulty of control, where he admits that his frequent sexual thoughts are driving him nuts. He's possessing pornography while combined. In sex offender treatment, he's writing obsessively regarding his obsession with underage girls, and everything in a consistent pattern, he's exhibiting this inability to control through these different factors that links back to his disorder that predisposes him, his psychological condition. It's for these reasons we ask that the First Department's decision be reversed. Thank you, Your Honors.
Thank you, counsel.